Um, all right, let's kick off our presentation for this week. So we have Jeff Holman that is going to spend some time sharing a framework around strategy that he has used with several of his clients. I'm excited to see what Jeff has to share. Jeff, if you don't mind just kicking things off with a 30-second background and overview on you and the firm, and then jump into your presentation, I'll make sure that you'll be able to share your screen.
Sure. Yep. I just tried and couldn't. So when you get that kicked off, let me know.
Now you can.
We're good. Awesome. Let me get the right screen here. Hopefully everybody can see this starting about now. Is that good? Show up? Awesome. So I appreciate it. And I will say I got 2 phone calls yesterday to present today at different opportunities. I picked this one. So I put the other one off till another day. But I'm really glad to be here. I do, I'm an attorney. I'm kind of boring. I'm an engineer. I'm even more boring. But I do some interesting things, I think, in the legal field, and I'm happy to share that today. Do you guys see, when I share my screen, do you see the little bar at the top? Does that block part of the screen, or is that not? You just see the slide. Okay. Just want to make sure. So what is strategy? Throw something in the chat, whatever you think that is. Let's get some discussion started. I always love the discussion that happens in the chat while the presentation's going. So throw that in the chat. While you do that, I'll give my little intro, and I'm just going to mimic what Taylor said. An engineer, MBA, an attorney showed up for a presentation, and I'm just going to leave it at that. So that's me. I did try to get 2 other rounds at schooling to knock off some of the what do you call it, introversion that accompanies most engineers. I don't know if it worked or not, but I'm still a work in progress. So Intellectual Strategies as a law firm, we cater to strategically oriented innovators, a lot of inventors, a lot of startup companies, things like that. The thing that we think makes us different, and this isn't necessarily a pitch, but to let you know the kind of the mindset I'm coming from, is we try to focus on what makes the clients we work with, the companies that consult with us, the companies that just call us up for, free advice. We try to focus primarily on what makes those companies different. What's their competitive advantage? Do they know how to actually articulate it? What is their team like? How does that support their competitive advantage? And then we get into the other stuff they're doing. Are they creating technology or branding or building a better business somehow? We'll help address those things. So that's me and where I'm coming from. Today, what we're going to talk about, and I think I got to move my water bottle so I can try to keep track of time here. I tend to go long, but I've got a short agenda for today. We're going to talk about strategy framework real quick, go into IP strategy. We're going to focus, hopefully, most of the discussion on what are valuable resources and assets. That's one slice of strategy. We'll do a little bit of application, and Taylor, if you want to remind me, we can do this. I can either do it instructional or we can maybe do it interactive with somebody on the call. And then, if we have time, or if I run out of other things to say, we'll talk about being chased by an Alaskan grizzly. But I'm just assuming if we can make it through 4 of these, we'll have a successful presentation today. So my definition of strategy that I use has 5 parts to it. Strategy, it involves, and you have to have all 5 of these to really be comprehensive strategy.
Jeff, your slides aren't advancing.
Oh, I've had that problem before. Where are we at now on your screen?
Still just an amazing picture of you.
Man.
Your joke setup. That's all. We're waiting waiting for the punchline.
Let me try this again. I'm going to share a window instead of a screen.
It's a pretty impressive beard as well, Jeff, in the picture.
Oh, thank you. So
Taylor could go toe to toe on your beards.
He's won me today for sure. Did that advance the screen by chance?
No, it hasn't.
Stop sharing. Awesome. Share. Let's just share a window instead of a screen. Does that help?
Not quite yet. It's just a black screen right now, Jeff.
Unless your story doesn't have a whole lot of bullet points, we're not seeing it.
So it doesn't share anything, huh?
Jeff, did you recently upgrade operating systems like Apple OS? Because
If I did,
you
my
might-
Microsoft Surface would be working differently.
okay, great. So no, that's not a problem. But maybe there's like a permissions thing between Zoom and
Yeah,
your
maybe.
OS.
Well, let me share a few screens, right? Let me do this. Let me get out of here. Let me start up something else. Sorry guys, I'm gonna open PowerPoint, do it from PowerPoint instead of PDF, and maybe it's a program thing. So,
Hey, well, we're waiting for this to load up. A public service announcement. The webcam on my MacBook is horrible, and so I've started using this software product called Camo, where I use my iPhone, and it's pretty amazing. If you're not satisfied with your webcam on your computer, look at Camo. No, I don't get any sort of affiliate revenue from this, but I've been really happy with it.
Thanks,
You
Jeremy.
see your slides now, Jeff.
This
you
works,
see a
yeah.
slide. Awesome. The punchline filled to this slide was simply, I'm not going to say any more than what Taylor already said. So that's about our firm. I already talked about that. Here's today's agenda. So we're going to try to make it through at least the first 4 of those today, focusing hopefully on 3 and 4, valuable resource discussion and some application to trademarks. So still advancing. We're on the strategy is slide. Awesome. Okay, so strategy has 5 parts in my book, and I think in a lot of people will have some version of this where strategy involves creating a plan. The plan is to leverage or deploy those valuable resources you have, and we'll go through this in a little bit. You deploy those resources for some type of sustainable advantage toward your business objectives in a competitive environment. And what that translates into is roughly this. So your plan is some, longer term outlook as to where you're headed. Your resources refer to those assets you have, or the team, or the partnerships, or in my case, a lot of my clients have patents and trademarks and other IP, but what are those resources that you've acquired that you can, or that you control, that you can deploy? And you use all those resources, of course, to create some type of sustainable long-term advantage, something that differentiates you and keeps you differentiated from your competition. And that sustainable advantage hopefully is oriented towards a leadership position in the industry for you. So leadership positions typically are things like cost leadership. You're the lowest cost provider, usually high quantity, or maybe product differentiation. You have a different enough product that people pay you whatever you're asking for it. So those are the very traditional leadership type positions. And then, of course, you're doing all of this within some competitive marketplace. So these are the factors, and we have like a framework to kind of walk through each of these and break things down. We're not going to do that today. We're going to go through, and in the time we have, focus on just the valuable resource part of it in just a minute. But before we do that, I just love this example of what I think was probably a very strategic plan that Walt Disney put together in 1957. On the left side of the screen there, it shows how he envisioned all of the parts and pieces to his little empire fitting together. And if we fast forward to I think this was from 2019 on the right, you can see that empire grew enormously. And while I think that the graphic is cool, if you take a minute and you actually try to map the things from the 1957 plan into this 2019 graphic, I was amazed at how one-to-one a lot of these things mapped over. Of course, they've added tons of other stuff to it, and there's new technologies and products and services that they offer, but there's an amazing correlation over, what is that, like 60 years that strategy played out. And I think it's because it's this, and maybe this is the very most fundamental thing that I would share today. If you take away, I'd be happy. The strategy isn't really about a plan as much as it is about a framework. Strategy is about, using those factors that I listed off to create some type of boundaries so that when you or your team or your customers are all thinking about your business, you're thinking about it with those constraints, and everything you do is framed by or constrained by those characteristics, those factors that you've deemed as important for your strategy. So I think Walt Disney did that. You don't have to be as elaborate. My strategy is a simple graphic. This is like kind of the outcome of my strategic planning. Somebody else came to me a while back and said, hey, we're investing $50,000 into our IP over the next couple of years. What should that generally look like? This is a proposal, pretty generic proposal for them, but a little proposal just to lay out how they might do that. I'm going to skip that slide. But I think that the important thing is when we start to get into assets and how you deploy assets for your strategy, and you talk about IP is definitely an asset. And when I first went in-house, in between running my law firm and now again running my law firm, I was trying to get a handle on how IP fit into the world, because they brought me on as an IP person. And I looked at all the different parts and pieces to a business, and not every business has these initially, but you'll have a lot of these. And I thought, well, IP is just one area where IP just fits into the asset pool of the business. But then I started seeing the impact that IP has on a business. It either drives value in places, or it drives discussions, or it's impacted by different parts of the business. And I think there's a legitimate case that IP is going to impact or be involved in all of these different green areas of your business in some way, shape, or form, sometimes very, very involved in that. So that was pretty alarming to me about the value of IP throughout the business. And so it was less of a surprise when a little while ago someone came out and said, well, the value of IP and intangible, IP is one form of intangible assets, but the value of intangible assets generally in businesses has risen from under 20% 45 years ago to close to, above 80% of a lot of businesses. It's all in intangible assets, the values that are there. And that's, if you go back to that other slide, that becomes less surprising, because there's so many aspects of the business that are built on the intangible assets and IP that you have. So one more thing.
Are you saving questions till the end, or are you?
No, you can ask questions now.
Okay.
I want to get, I'll make sure we get to if it's a long answer, I'll let you know.
Okay. So I would like some perspective on what you think about companies. I know Tesla is sort of like using Apple, but Elon Musk's strategy, or at least his purported strategy, about saying, well, I just want my IP to be out there so that we can make everything better. So I don't know if they still have protected IP, but in general, that you do hear people sort of saying that we should be sharing things. In software, there's a lot of common code that's used and things like this. So I don't know if you want to kind of address that now or later, but I think that there's sort of a vibe for some people that actually we should just share this technology instead of protecting it.
Sure. That's what's cool about IP and about strategy is every single business is unique in its characteristics, its team, its outlook, its objectives. And so IP allows you to do whatever you want with it. Is the grant of Tesla's battery technology, the dedication of that to the public, truly altruistic? Probably not. I mean, they need to build a market around their technology, and if they don't let anybody else use their technology because of their patents, they're actually, maybe cutting off their nose to spite their face, right? So,
right.
The software industry is another industry where you've hit it right on the head. There's a lot of people who feel it should be free. They feel that a lot of the patentable inventions are not patentable. I'm an advocate of doing whatever you want to do with your technology. I'm also an advocate of using the system as it exists to position yourself wherever you want to be. So if you want to dedicate your stuff to the public, that's great. If you want to demand that everybody else do it, but the system doesn't require them to, that's fine from a philosophical position, but it's a weak position to be in, I think. So I don't know if that answers your question in great depth.
No, it does. I mean, I think it just reinforces that there needs to be a strategy behind all of your IP decisions. And you're saying whether you go I'm going to try and protect everything or I'm going to give everything away, it's got to be, I mean, it makes sense that it needs to be tied to your overall strategy about what you're trying to do. And it can't, on Tesla's side, it could just be a giant marketing exercise to show that he's a super nice guy when in fact he kind of doesn't care because he feels like he's going to be ahead of everyone anyway.
Yeah, I mean, when you've got mega global corporations like that, or like IBM. I mean, IBM's been the leader in patent grants. They've gotten the most patents out of the United States patent system for like the last 30 plus years straight. Nobody beats them ever. I've done work with IBM. They actually throttle their workload to make sure they have enough, but not too many, so they can save the rest for the next. Like, it's pretty crazy. And they've built $1 billion licensing industry around their patent portfolio. But that's the outlier, right? They're the big dogs. They can do strategies that the rest of us don't have access to. So I appreciate the question. So real quickly, over time, you're going to see your mix of assets change, especially with IP up front. It's an idea. Down the road, it's patents. Then you create brands and strategic partnerships. That mix of IP assets or any assets in your business and how you deploy them will change over time. So if we get into assets specifically, and how do we say, okay, because here's the trap with IP. Every small business I know that's looking for funding says, I need patents. Why do you need patents? Because my investors want patents. Okay. So what is the value of the patents that you need? What type of stuff do you need patents on? It's like, I don't know. I just need a patent. And there are 4 characteristics for every asset. Doesn't matter if it's real estate, your team, your IP, whatever it is. In a business, there's a framework called resource-based view of strategy. And that talks about 4 different characteristics to evaluate each asset and whether or not it's a strategic asset in your business. And that is value, rarity, inimitability, and operational exploitation. And I'll go through each of those a little bit, but really what happens with IP is we short circuit this discussion and we say, well, legally speaking, if I can get a patent, then it's rare and nobody can imitate it or reproduce it, right? And so I satisfy 2 of those criteria right off the bat. And then we jump straight to the conclusion. We say, well, then it must be valuable to us. You can't do that. You can't overlook whether or not there's real opportunity for value or risk mitigation in that asset. And whether or not, I don't know if Garrett's on the phone, but on the line here, but Garrett and I had this conversation, whether or not you are actually in a position to take advantage of that value, to capture that value in your business, right? I could own the most elaborate, manufacturing facility in the middle of China, but if I don't have the ability to actually use that, then it's not a valuable strategic asset to me. And a lot of the patent, you might hear the statistics that 97% of patents go unused. I don't know if that's right or wrong, but it's going to be a high percentage because people are patenting things and claiming value when they're really just reaching rarity and inimitability without tackling the question of value and whether or not you can actually exploit that. I'm on some inventor forums and they're always like, I've got $1 million idea and I just don't have the funding to roll it out. I'm like, well, then it's probably worth something a lot less than $1 million, right? So if we look at, this is all kind of the theory of it, and I'm not monitoring the chat, so if there's chat stuff that comes up, let me know. But we're now at the 4th point in my agenda, and probably the last one. And this is, how do we apply this let's take a trademark context, right? Because if we can get a trademark around our brand or whatever, then it's going to have some exclusivity to it, and we're going to assume it's valuable. However, I've been in businesses where I go in and I say, okay, you've been in business for 7 years. You have 120 trademarks around the world on probably 12 different versions of things. Like, what prompted you to spend about $1 million to get these, and you're not using half of them, and you're not in half of the countries, and you where did you go wrong? Because you've literally wasted $500,000 at least on this. And I think it's because they were just in, acquisition mode with the assumption that IP would be valuable to them. So what I would propose is that if let's, instead of focus solely on rarity and inimitability, let's focus on a discussion around trademark value, and let's focus a discussion around trademark exploitation. How can I actually use that? And these are the questions that I think most small businesses or divisions of large businesses even should be asking themselves before they start allocating resources to go out and protect their brand, right? So I'm not going to go through this in detail initially, but just as a high level, there's really a couple different areas in each of these that people should be thinking about. So if you want to look at whether or not getting a trademark might be valuable, you want to look at what is the impact of having exclusivity for that mark. And for example, it might be different for one of your top brands than it would be for your company name. If you're not advertising, your company name as a house brand or something, you're really just advertising individual products. Those are going to have different value to you to be able to exclude someone from using your brand name of your product versus your brand name of your company. It also serves the purpose of clearance. It's not technically a clearance issue. Clearance means you're doing some analysis to see that it's okay for you to use your trademark or your brand out in the marketplace. How much exposure does that create for you from other people saying that maybe your use infringes their rights? So it's not technically for that, but it's kind of a pseudo analysis that relates to clearance, so it can have some value there. Actual valuation, like monetary valuation, are you doing this because you think it will increase the value, the enterprise value of your business, right? What impact will that have? And then from a branding standpoint, is getting this trademark actually creating branding opportunities for you, similar to Elon Musk, dedicating patents and making a big hoo-ha about it? Does it create an actual branding opportunity for you that you have your own trademark? Does it maybe centralize or focus your messaging within your team around something, because everyone's excited that you now have this Circle R, this registered trademark? So those are some high-level questions people can ask, and I'll share this list with everybody in other form if you want. But that's the question people should be having about, why should I really get a trademark? Is there even a possibility that this is going to be useful to me if I go out and spend a little bit of money on that? And then the second part of that is, let's say I do get my trademark. How am I going to use that? What are the capabilities I need to step through the process of getting and using that mark? So I break that down into these 4 categories. First of all, can you get the mark? Do you have the budget to do it? Do you have, the background? Do you know which mark you want? Is your mark does it qualify under distinctiveness and likelihood of confusion and use in interstate commerce criteria? Can you get the mark, right? Once you get the mark, can you promote it? And a lot of people say, can you get the domain name that goes with your mark? Can you get the social media handles? Can you actually go out and effectively use it in the channels that you want to use it in? If it comes down to it, can you enforce your mark? Do you have the means to do that? A lot of people have the means to shoot off a letter, but do you have the means prior to that to actually go out and monitor for infringing uses in the markets that matter to you? And let's say you shoot off the letter, do you have the means or maybe the appetite to go out and enforce that through court proceedings? You don't necessarily need to commit to that up front when you get the mark, but it's good to have an idea that if it comes down to it, do you have the ability to use the mark in that manner? And then separately, I think there's another, and this ties back into some of the others, but I think sometimes trademarks, we should think of them as potentially direct monetization resources for us. Can I actually go out and can I license my mark to somebody else and get money directly on that mark? Or maybe I can use it to set up a strategic partnership with somebody or co-market with another brand, and we provide part of what they do and we put our brands together on the product. So do you have the ability to do that? Or are you getting a mark just to go out and attract investors? or maybe you want to use your mark as collateral for debt financing down the road, things like that. So the question here is really, do you have a plan or the capabilities to use your mark down the road once you get it? So with that said, Taylor, I don't know where I'm at. I'm probably over. That's the
this
outline.
is great, Jeff.
That's the outline I wanted to go
thank
through.
you.
Can I stop sharing my screen and jump over to the chat or something?
Yeah, you can stop sharing if you'd like. One question that I had for you, I threw in the chat, and it was kind of also geared towards Clayton and Sarah, because I know they're in the M&A space or have been, and wondered with what you're talking about in terms of trademark and exploitation of assets, how does that impact an M&A strategy or being able to get value from those resources, those IP resources in a purchase transaction? Like, is there a good way to tie those two, valuation, etc.?
It depends on the industry. In some industries, you can actually correlate the value of patents or trademarks very clearly to more so patents than trademarks usually, but you can correlate the valuation of a business or some part of that valuation straight to the patent portfolio a lot of times. Trademarks kind of get lumped in with goodwill and end up being, the reason somebody paid extra above and beyond all the other assets. Trademarks fall into that usually. So they're in two different buckets. But I think in some industries, there are really clear valuation standards for how much a patent is worth. Other industries, you're not going to see that as much. I don't think software, you're going to see that as much, because there are a lot more questions around validity and enforceability of software patents than there are, and so you're probably going to have M&A analysis defaulting more to revenue, profitability, and user base than you would around the assets themselves. So I think it's industry dependent.
Sarah, what's been your experience?
Yeah, I would agree with what Jeff said in that if the patent is directly tied to the revenue model, the profitability model, or something valuable of the company, either subscribers or whatever it is, then there is a determinate, very easily determined value to that particular asset. If not, and it's a little bit more nebulous, and there's plenty of patents and IP out there that is less tangible or less relatable directly to exactly the revenue generation or the profitability of the company, it's a little bit more challenging to actually put your finger on a value per se for that asset. And so, and in fact, determining a value for that asset ends up being, actually quite difficult. And there's a lot of judgment that ends up being applied from people who have a specialty in valuing brands and so forth and so on.
Judgment is a nice word for it. I call it black magic.
Yeah, I mean, and they use the same valuation methodologies that one would for any other, valuation, but mostly it's comparables and, precedent transactions. And if there's no revenue attached to it or no financial measure attached to it, that method of valuation, it is dispensed with. But asset valuation is sometimes quite difficult with regard to, brands as a result. And it ends up being, as Jeff says, goodwill, which is, basically the premium you're paying for the business that owns that asset. Sorry.
And I think there's, I don't want to draw this on too long, but I think there's a point to be made here that, if I were to have my wish, I would say valuations, like I don't want to deal with monetary valuations because I don't trust them. People have different ways of doing them. A lot of those ways don't apply to patents and trademarks directly. What I would like to see more of in the industry is the ability for people to tell their story around their IP and how it actually aligns with their business. And as Sarah said, that means, does it support a primary business model or maybe a secondary business model in the business? Is it protecting some fundamental technology? And that's what the rest of my other 4-hour presentation that we'll go into next talks about, is how do you show that alignment between business strategy and IP? It's not, it's not easy, and it's never the same for any two companies, because every company is unique and their strategy is necessarily unique.
Jeff,
Jeff
do you mind
Spencer
if I
Loveless
ask
had a question. Go ahead. Go ahead,
I
Pete.
think I heard Pete talking.
Oh, yeah. I just wanted to ask Jeff, building on Phil's question from earlier, when you look at, let's take the case of software where someone wants to put some of their technology into the public domain, contribute it to an open source platform, but then their value, they want to have some capabilities or features that they are providing on top of that. What do you see as challenges for kind of segmenting where that proprietary IP begins and ends if you are trying to contribute some to the public domain, which obviously can have great advantage if you're trying to establish a standard and adoption, but then you want to be able to have proprietary components on top of that?
Yeah, it's a great question. If I'm talking with a patent-friendly client, I would say donate no more than is necessary to that open source system, and then everything else that gives that where you start to differentiate your business, you create your competitive advantage. I would protect that, and I would draw the line as close to that as possible, so that you're protecting that. I don't know what that looks like for a business necessarily without more context, but it'd be as little as possible, in my book, from a patent friendly client.
Have you seen any challenges in terms of defining where that line is?
Oh, sure. Yeah. The real problem is when people draft patents up front, they're like, well, we don't want to spend a lot of money on this patent. And they don't have necessarily in mind that they're going to, in the future, donate part of their technology to one of these protocols or standards. And so they package everything into one application, thinking it's more efficient, and it is financially up front. But then when you try to parse that out later, the lines get really blurry. And they're especially more blurred if you go to your patent attorney, who really doesn't know your business oftentimes, unless they're really integrated into that. And you ask for their advice, and there's other black magic happening on that end. So did someone else have, Taylor, you're talking about Spencer maybe had a question?
Yeah, Spencer Loveless, do you want to give any context on your question you threw in the chat there, Spencer?
Yeah, so I mean, we have patents, we enforce them, they pop up, infringers pop up all day long on eBay and Amazon, and it is just a nightmare to enforce. And where we're getting into additive manufacturing and 3D printing and being able to print anything basically tomorrow as you design it, there's going to be a ton of infringement going on in all over the world. I mean, how do you see that? I think the IP and law is going to have to somehow change so that you can take all these infringers down, because the system's so bulky right now that it just doesn't work effectively, in my opinion. But
yeah, and that's going to be more and more of a problem, like you're saying. I mean, one because now you become aware of it. It's much easier for you to find it, and it's also much easier for people to produce infringing products on a very small scale, which limits your incentive to go after them from a legal perspective. And so it's going to become more and more of a problem. I don't know what the solution is. I will say that right now, what we're seeing the trend towards is, and I don't think it's necessarily a good trend, but it is where it's headed, is using places like Amazon and Facebook and LinkedIn, these large forums that I think, frankly, from a political sense, should be considered public forums anymore. But these large forums are essentially facilitating that infringing activity, and they're also helping to police it. Now, in order for them to police it for you, you usually have to have actual trademark registrations, patent issuances. Like, you have to go to them with your with your actual resources, not just, oh, this guy stole my idea, or, you know, I have a domain, a website with my name on it and somebody else is using it. You have to take something to them, and that's the threshold they're using to then enforce. And it's maybe not as good as like a full-on investigation through the courts, but it's pretty efficient. You can go in there and be like, here's my trademark registration. They're using my name. And they'll usually shut it down and make the other person come back and tell you, you know, and explain why it shouldn't be shut down. How you do that on a large scale with lots and lots of people, it's still going to be a lot of time.
They shut it down and they pop up their own shop again, you know, under a different name, John's vacuum shop or whatever, and you can't. It's just,
yeah, I mean, my if I step back out of the IP world a little bit, and I said, well, how would I solve that problem for a client? My first gut reaction would be, what do we do to create? So instead of creating a product that is totally if we go back to the slides, valuable, rare, inimitable, and operationally exploitable, you're not necessarily rare or inimitable, so you're not meeting those criteria. It's going to be harder to call those strategic resources. How do you now translate those products into strategic resources? How do you make them more valuable, or in a way that you alone can exploit as a business? And, you know, if you go to like Clayton Christensen's book, he would say, well, you gotta figure out how to deliver a customer experience with your product, because that's where you're going to establish true competitive advantage. If it's just a product and it's easily replicatable or even substitutable, then you know the strategic value of that product is just going to be lower overall. So that's probably not a really good answer, not a quick fix by any means for what you're talking about, but you might look at becoming more than just a product and creating an experience in some way, whatever that means to your business.
That's interesting. Thanks, Jeff. We've got two more questions that have come up in the chat. Dale and Hallie have a question, and just so everybody knows, I'll keep this Zoom room open until noon, and we can hang out here as long as you'd like up till that point. Dale.
Thanks, Taylor. Dale? Where's Dale?
Can you guys hear me okay?
Yeah. We could, now you're frozen.
Inimitable side of this. The reason why I ask is because I'm wondering if there is a precedent for, especially in the software IP space, for certain concepts or patents to become so ubiquitous that they're no longer enforceable. I was working at Rosetta Stone. We were doing a Salesforce Service Cloud implementation, and someone that apparently had a patent on chat functionality, you know, from way back when, was going after Salesforce, saying that they had infringed upon their intellectual property rights because they owned the property rights to chat. And I could kind of understand why that could be legit for the, you know, in kind of the newness of chat, but now it's like chat's everywhere. Like, when does IP become immutable and no longer proprietary?
Two ways. Typically, one is it expires, either because it's run the course of its life, which for utility patents is 20 years, but for trademarks is infinite as long as you're still using it. But when it runs the course of its life, or you stop using it, you actually give up those rights. It ends. There is one additional way, kind of a sideways into giving up your rights, and that is if you have it but you never enforce it, even though you knew people were infringing it. And there's a legal doctrine called latches that says the law's changed in the last couple of years on that, but effectively it says if you're not going to enforce your rights, even though you know you should, then you're effectively giving up the right to it. You're not giving up the patent itself, but you're giving up the right to enforce it. But I mean, that's the thing about IP is if you can foresee the future direction of your industry, you can get a 15 or 20 or longer year, you know, head start on somebody and lock certain things down. You're never gonna like completely obstruct innovation in that industry. someone's going to innovate around you. And that's kind of the cool thing about what we're doing is, we're helping people create value, and yet that in a way incentivizes more value creation. Not all software engineers would say it that way, but that's one way to look at it.
Thanks.
Yeah. Hallie, did you have a question?
I do, thanks. Hey, Jeff, looking forward to our following up. Things have been coming into focus. So my question, in terms of what you were presenting with Walt Disney's, essentially it's a mind map, algorithmic mind map, and being able to see how all those cookie cutter pieces fit together in itself is an intangible asset, to know how the construct fits. So when it is a tangible device or an application, it's a lot easier to value or to present in terms of a meaningful asset. How do you value and how do you set those delineations for what is your contribution to a project? And I'm involved in something with just that kind of big picture new co situation now.
That's a great question. The different types of things that you work on would have different answers. From an invention standpoint, you would want to understand where the rights are in the actual patent application itself. And that's not even straightforward, because like for a provisional patent application, anything that you've contributed to the inventive concept in the provisional anywhere would be considered part of the invention. And so you want to make sure people understand you made a contribution to the conception of the invention described or illustrated in that provisional. For a non-provisional patent application, it's not about the whole overall disclosure, it's about the claims themselves. So you want to make sure that when that patent application is filed, if you want your name on it as an inventor, that everyone who's involved understands the contribution you made to certain claims, either individually or jointly with other people. So it kind of varies, and it depends on the type of IP vehicle that you're using. So, and that's important. I had a case where a provisional was filed with 2 inventors on it. Later, the non-provisional was filed, and the exact same claims that were in the provisional, and there was a split between the inventors. And I got a call from the other inventor's attorney saying, "Hey, this is wrong. You can't just take him off. You went and filed the exact same claims from the provisional into the non-provisional, but you took him off as an inventor." I said, "Well, that's because he didn't invent anything in the claims, even though we recognize some invention in the description overall in the provisional. That was never in the claims, and so he's not an inventor." And after they filed 6 other patent applications to dispute that, and it took about 3 years to work through the system, but they got dropped, and we came out, where we wanted to be. Anyway.
Jeff, thanks so much for your time today. This has been awesome. Do you mind putting your contact info in the chat so people can copy that if they need to? And
not at all.
Please reach out to. What's that? Oh,
I don't mind at all. Sorry.
Okay, cool.
I'll put that in there. And thanks so much for having me, Taylor. I always love talking about this stuff.
Yeah, this is fantastic. I really appreciate it. Thanks everybody for participating. Just wanted to let everyone know we're going to have a bye week next week for Thanksgiving. So we're not going to do Midday Connect, but we'll come back the week after that. And I believe that's the 1st of December. And we'll have Pam Jordan is going to be our speaker that week. She's going to be talking about the profit first concept, if you're familiar with that. So I'm excited to hear from Pam. So thanks everybody for coming, and we'll see you in 2 weeks.
Thanks.